Hello everyone. Thank you for joining us for today's Ius Laboris client webinar on restructuring companies in the Nordic countries during the pandemic. My name is Annie and I'm the Business Development Coordinator at Ius Laboris, and I will be facilitating this session for you. So presenters today are all lawyers from the Ius Laboris firms in Sweden, Denmark, Norway and Finland. And before we get started, I would just have a couple of housekeeping points to go over. So regarding your questions, you can send them via the question tab, and the presenters will answer as many as they can during the Q&A at the end of the session. You can also reach out to the presenters by email. Their contact details will be displayed on the slides, which can be uploaded in the attachment tab below. We would also appreciate any feedback that you can provide by using the feedback tab, as this will help us improve your experience. Okay, that's almost it from me. We're hoping that the line will stay good throughout the whole session, but we cannot guarantee there won't be any interruptions. We're all working from home, so if anything like that happens, we hope you will just bear with us. Okay, I will now hand over to our first speaker, Jenny Hellberg from Sweden. Go ahead, Jenny, you're welcome to start.
Thank you very much, Annie. A warm welcome to today's webinar. My name is Jenny Hellberg. I'm partner in the Swedish Ius Laboris firm NSL. I'm proud today to speak together with my long-term colleagues from the Nordics, and I will just briefly let them introduce themselves. Rikke, would you like to start?
Hello, my name is Rikke Falsampo. I'm a lawyer at Norway in Denmark. And Claude?
Hello, my name then is Claude. I'm also a lawyer and partner in York Law Firm, and we are located in Oslo in Norway.
And Seppo?
Yes, thank you, Jenny. Hello, my name is Seppo Havia, and I'm a partner working in Dittmar & Intrenius Attorneys at Law in Helsinki, Finland.
Thank you, everyone. As we have many participants today from different parts of the world, which we are very happy to have, we just wanted to give you a very brief introduction to the Nordics, as we often are treated by others as one country or one region. And yes, we are very much the same, but still different. Our legislation in general, and that includes employment law, has often been inspired by what the neighboring countries have done, but it's different in the details. And when it comes to employment law in general, Finland, Norway and Sweden tend to have more formal procedures and employee protection, for example, when it comes to unfair dismissals, etc. Whereas Denmark has the concept of flexicurity, but on the other hand is more focused on protection against discrimination. In restructuring situations, I would say that we have a lot in common. And of course, there are also a lot of regulation based on EC directives, which you also will recognize from other European countries. But today, we will look very, very brief at the main features of restructuring in each country and some differences between them. And the questions that we will be covering today is, before a company like yours are deciding to restructure, what do you need to address in each country when it comes to enforce these changes? And the first question we have is whether the coronavirus leading to bans or limitations on redundancies or other policies aimed at reducing redundancies. And generally speaking, redundancies are not banned in the EU countries, but there are slight differences in the approaches in the different countries. And the second question is, if there is no ban, what issues must a company consider before carrying out a major restructuring? And those are the first two questions that we will talk about, and then we will end up with a question 3 with the do's and don'ts, the important things to think of in each country. So let's start off with Sweden then. And for question 1, in Sweden we do not have any restrictions on restructuring and redundancies due to COVID-19. We have a state scheme on short-time work and state support, where the costs for the short-time work shall be shared between the state, the employer and the employee. The employees will have reduced working hours of 20, 40 or 60%. And also now as from May, there is also possibility to reduce up to 80%, but that will only be applicable for May, June and July. The employees will also contribute to this by reducing their salaries with between 4 and 12%. As you can see from this slide, employers will also receive state support for a significant portion of the salary costs. This said, this state support scheme is put in place to avoid redundancies, which means that it cannot be used if the employer needs to make employees redundant. That is the main rule. However, during the corona crisis, an exception has been implemented. This exception means that if an employer has implemented short-time work to avoid redundancies, but during such time, these changes and the employer situation becomes worse, the employer can actually make employees on short-time work redundant and still receive state support at the same time. This means that employers actually in certain situations can get state support for redundancy costs. And that is a big question in Sweden at the moment, because the state are at the moment supporting a lot of companies with this. We will now turn to Norway and Claude.
Thank you for the introduction, Jenny. So for Norway, it is basically the same as in Sweden. There are no general restrictions on the right to conduct redundancies under this specific pandemic situation. We have many state support schemes, but none of them specifically put limitations on companies' employers' right to consider and conduct reorganizations and redundancies if necessary. The ordinary rules apply. I think I would like to point out that in Norway, we have a quite efficient layoff system. We have always had the possibility to decide to put employees on layoff in case of temporary reductions in the need of workforce. And during the corona pandemic, this system has been also adapted in a way that the Norwegian government, they have reduced the costs for the employer, basically that the employer's contribution with salary during layoff has been reduced, and at the same time the government has also increased the payments to the employees who are put on layoff, which basically is that they receive unemployment benefits. So as a consequence, and so far most Norwegian companies facing difficulties during the corona pandemic, they have chosen to use layoff instead of redundancies. But we are now seeing an increasement in companies who now see that they need to consider redundancies, because redundancy is a measure that you will use if it's a more permanent situation and if we see that it's not a temporary. So I think I will let it with that and hand over to Ulrika.
Thank you, Seppo. I will just change the slide. There are no general restrictions on redundancies in the context of the current COVID-19 situation in Denmark. However, employers must be aware of the fact that starting a redundancy process may have economic consequences if they use some of the special COVID-19 initiatives introduced by the government. Under the introduced wage compensation scheme, employers can, subject to various conditions, send home employees with full pay and receive compensation. And it covers the period 9 March 2020 until 8 July 2020. In order to be eligible to use this scheme, a minimum of 30% of the workforce or 50 employees as a minimum must be sent home, and the compensation amounts to 75% of the gross monthly pay for salaried employees or 90% of the gross monthly pay for blue-collar employees. And the cap is, in both situations, 30,000 Danish krones per full-time employee. If you receive the wage compensation and carry out redundancies, the entitlement to receive the compensation will end at the date of the first dismissal. Also, the government has eased the rules about work distribution schemes and made the scheme more flexible. The work distribution scheme means that the employer can partly lay off employees and distribute and divide the work at hand between the employees. In the period when the employees are laid off, they will, subject to certain conditions, be entitled to receive unemployment benefits. The scheme can be introduced in a company as a whole or within a specific department or production unit, but it will, unless there is an applicable CBA regulating this, require an agreement with the majority of the employees. The work distribution scheme will automatically end in case of redundancies in the department or unit where the work distribution scheme applies. And besides the wage compensation scheme, the government has also introduced a scheme on compensation for fixed costs for businesses facing a decline in turnover, and also made it possible for employers to postpone payment of certain taxes. And now, turning to you, Seppo.
Thank you, Rika. In Finland, the situation is same as in other Nordic countries regarding restrictions on redundancies. So basically, there are no such general restrictions. As regards financial support schemes, at the moment, two different schemes are being prepared by the Finnish government. And the government is now proposing direct monetary support instead of prior indirect support like loans, guarantees, and support for development of companies suffering from the coronavirus. But as I said, now there is a plan pending and a government proposal pending which would give companies direct support, monetary support. And the support is basically divided in two. If we first take the support for restaurants, of course, restaurants were closed in Finland as of 4th April and are now beginning to open again as of 1st June under certain restrictions. Restaurants have suffered a lot and lost almost completely their sales in April, May. And therefore, the direct support package for the proposal for restaurants is a total of 123 million euro, which would consist of two parts: wage support to restaurant companies, which would be 1,000 euro per employee, internally speaking, and then the other part would be support for decrease in sales. And if the sales in restaurant in April would have been less than the average sales in January, February, before the corona situation, the restaurant would get a maximum of 15% compensation of the decrease in sales and a maximum of 500,000 euros per company. Then there is in a proposal for a more general support for companies. And this support scheme is irrespective of the business sector in question. And it is intended to compensate direct costs like wages and rents to save companies from bankruptcy during the corona crisis. And there is no basically payback obligation regarding these direct costs, according to proposal. However, condition for support would be a so-called remarkable decrease in turnover or sales, which would be, the criteria would possibly be that the decrease would have been or should be at least 25% in sales. And therefore, it is clear that basically at least the service sector, which have suffered a lot, will be the one most likely fulfilling the criteria for support and using it too. Amount of support would be most likely between 100,000 to 200,000 euro, a maximum per company. the total package of this general support, monetary support, will be worth of hundreds of millions euros. Some sources say that it might be even worth over 1 billion euros. And some say that even 40–50% of Finnish companies might be entitled to get this support based on decrease in sales. This plan and the payment of this support, it is expected that it will be ready after the parliamentary proceedings have been successfully done in June at the earliest. And then we will move on to our next question, which will be if there is no ban on collective redundancies, what issues must a company consider before carrying out a major restructuring? And the first in turn would be Rikke.
Thank you, Seppo. Well, if you consider carrying out a major restructuring, it's important to keep in mind that it may be required to inform and consult with the employees or the employee representatives. First of all, the Act on Information and Consultation of Employees lays down various obligations on information and consultation prior to carrying out a major restructuring. The Act applies to companies with more than 35 employees. According to the Act, the employer must inform the employee representatives, usually through a works council, about proposed restructurings. The employee representatives must be given sufficient information to ensure that they are able to express their opinion on the situation so that the employer can take their input into consideration in the decision-making process going forward. If there are no representatives and no works council, the process must in principle be carried out in relation to all employees. Also, it's relevant to assess whether the thresholds in the Collective Redundancies Act are met when planning a major restructuring that may lead to redundancies. And you can see the thresholds on the slide. If the employer has several places of work in Denmark, the thresholds are, as a main rule, calculated on a regional basis. The consequence of this is that the thresholds may be reached in one region, but not in another region. And the employer would then be required to follow the process in the region where the thresholds has been reached and not in the other region. And this sometimes causes employers to decide to follow the process in all locations, but you should note that this is not a requirement. If the thresholds are met, you must inform and consult with the affected employees or the representatives about the proposed redundancies, and the aim of the process must be to avoid or reduce the number of dismissals or mitigate the effects of the dismissal. It's therefore very important not to make any final decision on carrying out dismissals until the information and consultation process has been completed. And the Regional Employment Council, which is a Danish public authority, must continuously be informed throughout the process. A consultation process of 5 to 7 days may be adequate in some situations, and sometimes it may be even shorter. But if at least 50% of the employees will be made redundant, and the workplace usually employs more than 100 employees, it's important to know that stricter rules apply, and this will result in a longer process. And it's very relevant to know that the final decision is for the employer to make, and that the employer is not required to accommodate the employees or their representatives' wishes. No agreement must be reached, and the employees or their representatives do not have a right of veto or option of delaying the redundancies. And finally, if a collective agreement applies, it's always important to check if the agreement contains any relevant information and consultation obligations. Usually they do, so you need to check that out prior to initiating any redundancies. And now we are turning to you, Jenny.
Thank you very much. In Sweden we do not have any restrictions implemented in relation to collective dismissals due to COVID-19. That said, it is important to know that in Sweden we do not have a distinction between a dismissal of one or a minor number of employees, or what we would call in the Nordic countries and the rest of Europe, of collective dismissal. In Sweden, you have to follow the same procedure regardless of the number of affected employees. This is what I would say the key difference between Sweden and our neighbors in the Nordic countries. This goes back to our long tradition of consultations between employers and trade unions. Employers have a far-reaching obligation to consult with trade unions in various matters, and where there is a legal right to consultations are given to the trade unions. Individual employees or representatives of the employees do not have such right, in particular not in restructuring situations. However, and this is very important, trade unions do not have a possibility to block an employer's decision, for example when it comes to restructuring, only to be given a possibility to have a say. Once the consultations have taken place, the employer is free to decide upon how to organize its business and implement a restructuring. The decision itself cannot be questioned or tried in court, and that is what I understand different to many other Central European countries. Instead, there are other ways to protect employee rights in restructuring situations, and compared to what I just mentioned, these rights are given to each individual employee. In essence, it is what we call the last in, first out principle, where employees with longer seniority shall be given priority to remain employed, but not necessarily keeping their current position or salary. This is, of course, provided that they have satisfactory qualifications for any of the remaining positions. And to summarize this, these questions on last in, first out and satisfactory qualifications are usually the most challenging ones in a restructuring situation in Sweden, and where there is an expectation among employees to be paid a severance, if not followed. Still, court cases are very uncommon, as the parties tend to and prefer to settle. I would say that this is in essence what Swedes are like, consensus driven. And that was it for Sweden, and now we turn again to Claude in Norway.
Thank you, Jenny. Yeah, so for Norway, well, it's the same starting point as in Sweden, with no specific restrictions on our rules for collective dismissals if they occur as a result of the pandemic situation. I would like to point out that since we are focusing now on major restructuring cases, but still in Norway it is the same rules that apply. It needs to be justifiable whether it's one employee you consider make redundant or more employees. The major difference is, like in also in Denmark, that if we are facing a larger number of employees, there are more strict formal procedure that the company has to go through, and that has to be done before the company makes the final decision to start the reorganization, which again has as an effect will imply redundancy. That is important to be aware of. And then again, to make it even more complicated, like in Sweden, we have also a long tradition for collective agreements, including unions. And if the company is bound by a collective agreement, you can just take that into assumption that there is an obligation to consult with union representatives, employee representatives, before the final decision is taken by the company. And that obligation applies independent how many or how few employees you consider to make redundant. So that situation is quite similar to Sweden. But if the company in question is not bound by a collective agreement, well then we will have to look at our mandatory rules, like in Denmark, and where we are dealing with what we also call known as mass redundancies. And in Norway, a mass redundancy is defined if you have 10 or more employees at risk in a redundancy situation. But the same for both situations. The company has to bear in mind that these collective consultations need to be fulfilled and completed and documented before the company makes the final decision, and that kind of decision, especially if it's a major downscaling, is normally necessary to have in a board meeting. There's also limitations for which employees can be made redundant. So in Norway, employer cannot automatically dismiss employees who are so unfortunate to be the ones in the positions that are made redundant. Quite similar to Sweden, but still a little bit different. We have to make a selection among the employees based upon justifiable criteria, such as qualifications, obviously, for the remaining positions, length of service, social circumstances, etc. And as a starting point, you need to do this assessment among all employees in the company. So needless to say, this could be quite extensive and comprehensive work for the HR department. And according to Norwegian case law, there is a quite strong burden of proof for the employer to be able to demonstrate that the whole process has been done correctly and all facts have been checked and all assessment has been done a couple of times in case of disputes in court. And disputes in courts are not seldom in Norway in these cases. I think I will end with that and turn on to Seppo.
Thank you, Claude. Yes, in Finland, to make employees redundant, it requires a so-called proper and weighty reasons for termination. And as in Sweden, same applies to collective redundancies, no matter if it is, say, one redundancy or more. However, with regard to the redundancy or restructuring procedure, there are major differences depending on the size of the company in terms of number of its employees and number of contemplated redundancies. We will discuss these on the next slide. Maybe the most important rule to remember in Finland will be or is that no final decisions on redundancies can be made before you have contemplated and fulfilled the whole cooperation, employee consultation cooperation procedure. And the same applies to parent company to abroad, outside Finland. The parent company cannot make the final decision affecting on the Finnish subsidiary before the Finnish subsidiary has fulfilled its cooperation consultation procedural obligations. There is basically when we discuss about collective redundancies and the grounds for redundancies, you could say, or one could say, that there is a two-stage evaluation to fulfill these legal grounds for redundancies. And the first is that the amount of work available in the company must have diminished substantially and permanently for financial, production-related reasons or as a result of restructuring. All of these three reasons, they can occur separately or, which is very typical, jointly, especially production-related reasons and reasons relating to restructuring. Restructuring, the employer is always or has always right to restructure its business the way it feels it is best. It doesn't need to be basically, there doesn't need to be a reasons relating to loss of finances or production-related reasons, as long as the restructuring leads to a situation where the work available to be offered to the employee or employees in question have diminished, as it stated here, substantially and permanently. And what is substantial diminishment of work. Basically, according to case law, as a rule of thumb, you could say that if the work has diminished more than 50%, it's substantial. And permanent would be that there is no increase in work in the near sight. Then the second stage would be that if the employee, instead of making the employee redundant, can be reassigned or retrained to another available position in the company, then the company cannot make the employee in question redundant. But if these two stages are fulfilled, then the employee can be made redundant. Then, as regards the procedural rules around the restructuring, we have this so-called Act on Cooperation within Undertakings, which applies to major employers employing at least 20 employees. For smaller employees employing less than 20 employees, the rules regarding the procedural rules, they are set out in the Finnish Employment Contracts Act, and they are much more lighter than the procedural rules in this Cooperation Act, which the major companies have to follow. And then for these major employees employing at least 20 employees, there is a dividing factor also regarding redundancies, which is the number of contemplated redundancies, the number of employees you are going to make redundant. If it's at least 10, there is an obligation to have at least 6 weeks negotiation period to consult with employees or employee representatives. If the number of contemplated redundancies is less than 10, then 14 days is enough as a minimum consultation period. Then, due to this COVID-19 situation, the Finnish government gave a new temporary amendment or act regarding temporary amendments to employment laws, and one or two of these specific temporary rules include that now until the end of June this year, employers can make employees on probationary period also redundant based on collective redundancy reasons. This hasn't been possible and will not be possible after this temporary, most likely after these temporary amendments. But at the moment, this is possible. But if you make an employee on probationary period redundant, then you have the same obligations regarding so-called re-employment of if you have work to offer during the following 9 months after the expiry of employment. You have to offer these employees also you have made redundant on probationary period these possible work you have as regards with normal situations or normal redundancies. And keep in mind that this period of re-employment has been also temporarily extended from normally applicable 4 and 6 months period to 9 months, which is now in force until the end of June this year, and will most likely, according to current understanding, be extended further until the end of year 2020, but no final decision on this has yet been made. And the decisive criteria will be that if you give notice of termination to employee before 30th June, then this extended period of 9 months will be applied. There is a major difference between, for example, Sweden and Finland with regard to, as Jenny explained, so-called last in, first out principle. In Finland, we basically don't have such principles. There are some principles, last in, first out principles set out in collective agreements, but they are much more vague. They are not similar as the law-based requirements in Sweden. However, you have to keep in mind that no discrimination or discriminative criteria can be used. So as long as you use criteria like competence, experience, objective criteria regarding the employee skills, then you are basically quite free to choose the employees in question. Of course, those employees whose work diminishes the most will typically be made first redundant, but you can also choose to some sense between employees. Then we will transfer to third questions or do's and don'ts. What are the main do's and don'ts to consider in each of our Nordic countries? And please feel free, Claude, to continue.
Thank you, Seppo. Yeah, so it is of course impossible to cover all details and all different issues that may arise in a webinar like this, but anyway, the purpose now is to try to cover at least the major topics, so you have some key points to remember from this session. I have tried to sum up some do's and don'ts here. Basically, to plan restructuring time. Of course, that is often a key to have a successful outcome of a process, but often HR managers face the opposite, that there are a lack of time. But still, if you have time and can plan this carefully, that is often rather important. And also, as part of this process, quite early, try to identify if there are difficult cases, issues. And that typically is questions related to the selection process, which I briefly described, since you need to conduct a rather extensive analysis and selection among all employees in the company. So you would need a matrix with overview, with length of service, age, tasks, etc. So and this takes time, typically in major reorganization projects. Also important, I think this is quite common for the Nordic countries. We like to be transparent. We like to be informed. Keep employees' representatives and employees informed on a regular basis. I think that's quite important to understand. It's a part of our culture. And at least it will make the process going smoother often. Town hall meetings, written information, etc. can work fine. And also for Norway, remember always to check if there are any collective agreements involved in your Norwegian company. And especially for HR managers working from other countries, they don't necessarily have the overview, but I cannot just emphasize the importance of verifying this before you do anything. For the don'ts, well, I think it goes without saying, you need to have a plan and strategy already in place before you start consulting with employee representatives and unions. And often it's necessary also to sum this up in a written invitation for consultation. that's even a mandatory requirement in case of mass redundancies, and also if you are is also the best practice if you are dealing with collective agreement consultations. Also, don't forget, if we are dealing with a mass redundancy in the meaning of the law, as a 10 or more employees at risk, you also have an obligation to notify the local labor and welfare administration. And that has to be done at the latest the same time when you invite the union and or representatives for consultations. It is also, of course, important to complete all these consultations before you make the final decision. Make sure everything is also documented. I cannot emphasize that enough either. The process needs to be documented all the way. And lastly, but not to forget, I've been focusing most on the formal collective consultation process, like the other countries. But in Norway also, we have, after the collective consultation process has been completed, the company has made a decision, the employer has made the selection process based upon the selection criteria that has been discussed and hopefully agreed upon with the representatives. Then the employer also is obliged to call each and every employee at risk for an individual one-to-one meeting, where the employee also is entitled to have a representative with him or her. Purpose with the meeting is for the employer to present the preliminary assessment and why the person is at risk, and for the employee, of course, then to come up with comments and arguments for why the employee, for instance, should not be at risk. And first, after that formal meeting, then the employer can make the final decision to dismiss on individual basis. And all these individual meetings should normally be completed before you can make any single decision. I will pass to Ulrike.
Thank you, Claude. Well, if a business is under an economic pressure, first of all, it's relevant to consider if there are any of the government-funded economic packages, such as the wage compensation scheme and compensation for fixed cost schemes, that could be useful. Even though things are finally slowly getting back to normal here, it's not too late to send home employees and apply for wage compensation if this is relevant. And if you do make use of the wage compensation scheme, then remember to avoid, as already mentioned, making redundancies, as it will end your entitlement to compensation. You can, however, start the information and consultation process if collective redundancies are necessary before the wage compensation period ends, as long as the final decision to carry out the redundancies is not made during the period. If the economic packages are not enough to get you through the crisis, it's relevant to consider other alternatives. An example include reduction in working time and salary. Such changes are material changes to the terms and conditions, so you must, as a main rule, respect a notice equivalent to the individual employee's notice period. But it is possible to implement it without notice if the employees accept such immediate implementation. In the past few months, we've seen many employers propose initiatives like these that have been limited in time, and we've also heard back from clients that the employees have generally accepted and supported the initiatives. If you decide to unilaterally implement changes to the working time or salary, do remember that this may also trigger an information and consultation obligation. The reason for this is that simply providing notification of such changes will count as a dismissal, and therefore such notification must be included when you calculate whether the thresholds in the Collective Redundancies Act are met. If none of the above alternatives seems relevant, it's necessary to consider making redundancies, and if the process is well prepared, it's usually not complicated or lengthy, but you need to keep a few things in mind. Remember to calculate the expected number of dismissals and assess whether the special process in the Collective Redundancies Act will apply, and always check whether there is an applicable CBA that may contain regulation in this regard. If the special process must be followed, make sure that it's stressed in both oral and written communication that no final decision has been made or will be made before the information and consultation process ends. And make an action plan to ensure that all required steps are taken, including continuous communication with the authorities. Communicate clearly and in a timely manner with the employees, as in Norway. And this is the foundation for being able to implement these redundancies in the most efficient way. And this is also the reason why we, as a main rule, recommend not to carry out multiple individual redundancies in a short period of time instead of one major redundancy process. Several individual redundancies may give rise to confusion and demotivation amongst the employees that you are aiming to retain. And of course, it's essential to carefully plan the selection process for redundancies to reduce the risk that the affected employees file a discrimination claim or other claims. And in this process, it is first of all important to be aware of employees enjoying special protection. There is no ban on dismissal of any employees belonging to a protected group, but a reversed or split burden of proof will generally apply, and this could give rise to substantial claims for compensation. Discrimination claims in redundancy situations are quite normal in Denmark, so this is indeed something that you need to have extra focus on in the process. The selection process must be based on objective and fair criteria, and in order to get an overview of the employees and the selection process, it may be useful to prepare a selection criteria assessment in writing. And this will enable you to get a full overview of the assessments made, and then you will, if the employees later object, already have the documentation in place, which may come in handy. And throwing the ball to Sweden and Jenny.
Yes, thank you very much. As I mentioned before, the most challenging questions in a restructuring situation in Sweden are usually the ones about the last in, first out principle. Therefore, to have a strategy and to plan the restructuring is crucial. And if you're not planning to follow this principle, maybe to do some cherry picking, you need to make a careful assessment as well as being prepared to make settlement agreements. Such agreements would be with employees with longer seniority, where they theoretically have the qualifications for the remaining positions. They will be able to do the job, but maybe according to the employer, not the best or the preferred one to do it. And you would instead like to keep people with shorter seniority. If it's a large number of dismissals, it's advisable, as Claude also mentioned, to have a matrix and to really go through this in detail, but also to have a policy and stick to it, outlining what is offered in terms of severance and so on. But please note that there are no legal requirements to pay severance or a set formula how it should be calculated. It depends on the circumstances. Another important thing is, of course, to understand which trade unions you should consult with. If your company has a collective bargaining agreement, as Claude again said, it's very important to know that. And if you have a CBA, you should consult with the trade unions party to the collective bargaining agreement. That's easy to find out. But if the company does not have a CBA, you need to ask the affected employees if they are trade union members, and if they are, which union. This might be considered sensitive task for a non-Swede, but that's not the case. However, please be aware that as soon as the question is about trade union membership is asked, employees understand there is something going on. So therefore, communication is crucial also at this stage of the process. As part of the planning, you should also do a risk assessment from a work environment perspective, which means that you should identify and assess and take action when it comes to the work environment aspects of the restructuring. And you should involve relevant stakeholders, for example, managers, safety officers, and others. And once you start the restructuring process, as Claude already have mentioned, again, do make sure to keep employees informed on a regular basis. And as he said, it's part of our culture to do so. And I will now leave it over to Seppo.
Thank you, Jenny. I will go through these quite quickly so that we will have time to handle these, at least some of these questions which we have received. So what to do, especially in connection of restructuring process in Finland? Of course, as in other countries and as always, try to plan as good, as well as possible in beforehand, before you begin any restructuring process. What to do, what kind of process you have, and what kind of information you will deal with employees. And what is important to, of course, do is to form some kind of strategy that how you will hold on to valued staff. For example, if you can limit the scope of redundancies the way that the valued staff is not in risk of getting wrongful information. This is more like HR policy issue also, but try to understand or try to keep those valued staff understand that they may not be in the scope of being made redundant finally. But that's of course some kind of trying to find balance with the fact that at the same time you cannot have ready-made decisions and then you cannot choose employees before you have concluded the procedure. Try to make use some alternatives for restructuring, for example, these state supports which we discussed before. Maybe using holidays now. There is a holiday period going on, holiday season. Maybe in many cases it's a one way to get some minor impacts on savings. Salary cuts, basically unilateral salary cuts, are not possible in Finland. It must be based on mutual understanding and agreement with employees, basically, unless the company is almost in bankruptcy. Reduce working hours to transfer into temporary work, for example, instead of redundancies might be one way to mitigate the impacts of redundancies. As I said, communicate with your workforce and especially with employee representatives and keep them updated. Keep detailed minutes of the consultation process. It's not necessary or mandatory according to law unless some, for example, employee representatives so requires, but employers should always keep minutes. And at least what the law states is that you have to record at least different opinions and possible decisions and agreements you may reach, and a list of participants. Don't do any final decisions as discussed previously before ending the consultation procedure. Don't forget to have a so-called statutory plan of action to promote the re-employment of dismissed employees. In case you are intending to make less than 10 employees redundant, this is not so severe obligation, it's much more lighter. But especially in cases when you are contemplating at least 20 redundancies, then don't forget the statutory plan of action. And don't discriminate depending on the age or whatever discriminative reasons. As soon as you don't do this, and don't make yourself guilty on unequal treatment in connection of selection of employees who to make redundant, you manage quite well. Okay, that was the material side of our presentations, and then finally some closing words or remarks. We all hope that you have found this presentation interesting. And we hope that this has given you some useful highlights to restructuring matters in our Nordic countries, especially due to coronavirus. And as we have heard today, and as Jenny, for example, explained in the beginning, Even though there are similarities between the Nordic countries, there are also major differences in legislation and country practices, how to handle restructuring processes in the right way. And this is important for everyone to understand and know when you are planning restructuring in different Nordic or any other countries. And with the careful planning already before the restructuring process, you may save your company from possible damage claims and avoid any unnecessary reputational risks too. It can also save you a lot of money. And I would like to also mention that our 4 law firms work very much together on a daily basis, where we, for example, can coordinate any work between us. Every year we also have at least 1 full-day seminar together covering the hottest HR law topics in the Nordics. This year, as we hope, it will take place in Copenhagen on the 19th November. However, as we know all, let's see how the corona situation evolves and whether such a seminar is possible to organize in person. If not, maybe we will organize it as a webinar. Nevertheless, if you are interested to join, please contact any of us and we will be happy to send you an invitation later on. And the slides on the screen now, if you would like to have information, for example, on restructuring countries from outside the Nordics, Ius Laboris have produced a guide on restructuring, including do's and don'ts in total of 20 of the world's largest economies, like Germany, France, etc. If you get in touch with any of us, we can send you a link to that document. We are also at the moment preparing and publishing a similar guide for the Nordic countries especially. So please just let us know if you wish to receive that publication and we will send it to you. That guide will cover also some of the matters discussed today. And on my and my colleagues' behalf, I would like to thank you all participating for this webinar. And I will now pass on word to Annie Laakso from the Ius Laboris Central team.
Yes, thank you, Seppo. Unfortunately, today for questions, we don't have any time. We're very conscious of time, so unfortunately, we need to skip this. But for any queries and questions, you can contact the presenters by email, or the presenters can contact you. But if your queries, however, related to a different jurisdiction, you can contact me at ani.laakso@iuslaboris.com or go to the people pages of our website to find the right contact. And then for some insightful information and further updates on the coronavirus, I recommend you visit the Ius Laboris Corona page, which is regularly updated as the situation evolves. From there, you can upload our coronavirus guide for international employers with information from 58 countries. Don't forget that you can also find all this information in the attachment tab. Finally, myself, I would also like to thank everyone for attending, and thanks also to our presenters for their insights. So with that, this webinar will now be ending. Thank you.